I think.
Or what about a state in which there is no such process? I mean, we have Texas here that has a process for appealing all the way through and getting a conclusive determination. But I suppose Texas didn't have to have Rule 64 or Article 64. And so if you have a state in which the DA says, I'm not going to give you DNA testing because of how I understand the law, what's your view as to whether or not a person could go directly to federal court at that point and maybe not even go to the state?
Your Honor, I think in that, of course, it's not before the court, but I think in that case, the person could go directly to court. They would be able to say, I view the district attorney's action as enforcing this law, and I think the law is unconstitutional in whatever the ways are.
And so it's ripe at the point at which the person is denied, ripe for the purpose of going to federal court. But I thought your answer to Justice Kagan was going to be, we're not really in the injury discovery rule world. In other words, she suggested that the person, why don't we say that the person isn't harmed until he gets to the end of the state process? But that seems to me to assume that we're looking for an injury when we're talking about accrual in this context. And I had understood, Justice Scalia in the TRW case, for example, to say that in a 1983 case, we're not really looking for injury in that same way. We're looking for the cause of action to be complete, which is, I guess, the determination that you don't have DNA testing in this situation.
I think the injury, Your Honor, is the deprivation without due process of the liberty interest in proving your innocence with newly discovered evidence.